Today I will be looking at a mistake that many fathers make in presenting an illogical position to Cafcass and the family court when it comes to making allegations of domestic abuse against the mummy being the resident parent. I am of course Philip Kedge, the director of the brilliant McKenzie Friend UK network, where nothing I say is legal advice and where all of my views and opinions are, of course they are, entirely my own. Now for all of your family court needs, please contact me today at contactphil.co.uk. So the mummy has denied child contact with the father and is throwing accusations of domestic abuse. Of course she is, that is common and almost expected. It is all part of the playbook of how to throw the father under the family court bus. Now the father submits a C100 application stating that he wants 50-50 shared care or some other regular contact and throws allegations of domestic abuse back at the mummy. Now the father's position is unfortunately somewhat illogical and unlikely to be taken seriously by Cafcass or the court, and this is why. The father has stated that he wants 50-50 shared care or other regular contact, which means that he is happy that the mother has the other 50% of contact or agrees that she is the resident parent. So when he then throws allegations of domestic abuse, those allegations are not going to be taken seriously because he can't really be that concerned as to the mother's behaviour or the impact on the children, if he is happy for the mother to have significant contact with the children. Now compare that to the mother's position, who has stopped contact and then made allegations against the father. Cafcass and the court are going to take her allegations far more seriously, as the mother has taken steps to safeguard the children by stating that contact is unsafe and has been stopped. Hence her allegations are going to have far more weighting and will be taken more seriously before any consideration to reinstating contact. Now things are going to get far worse for the father. By presenting that he has an illogical position about domestic abuse and the mother having contact, Cafcass may well then consider that his allegations are spurious and that all he is trying to do is to intentionally disparage the mother, that he is not focused on the children and that his allegations are all part of the coercive controlling behaviour that the mother is stating that she is a victim of. The father has now made his position far worse, where his allegations against the mummy are likely to be held against him, making his journey through the family court far more difficult. So, in conclusion, for non-resident parents, who are the mostly fathers, making allegations of domestic abuse is only really logical when your position is that the allegations are so serious that the mummy should not have any contact until safe to do so with safeguarding interventions. But the reality is that it is entirely unlikely that the father's allegations will get anywhere near that threshold. Fathers are all too often on a hiding to nothing, and so many fathers fall into this trap. Their positions when making allegations of domestic abuse are illogical and meaningless, which are then turned against them as intentionally disparaging the poor, downtrodden, coercively controlled mummy, who the family court wants to wrap up in cotton wool not to upset her, in the best interests of the children. So that's me done, folks. Am I right or wrong? You tell me in the comments below. And for all of your family court needs, contact me right now at contactphil.co.uk. Until next time, stay strong.